do not object to the bifurcation process, Your Honor. They have not presented invoices to us in any accounting as of yet, which we will be reviewing and then challenging as appropriate. So she asked for 60 days, and I have no problem with that.
Okay, the court will retain jurisdiction to deal with the issue of cost of prosecution and other costs, I guess, pursuant to Chapter 938. That's the statute that you're seeking those costs under?
It is, Your Honor.
Okay. Mr. Mason, mitigation. You may proceed, sir. Okay.
We have, however, the argument, the legal argument, is trying to double jeopardy.
Go ahead. All right.
May it please the court?
Good morning.
Good morning, Your Honor. Your Honor, before sentencing, we respectfully request that the court address the violation of double jeopardy at issue with respect to counts 5, 6, and 7. Because all four statements in the indictment arose during the July 16th interview between Detective Melich and Miss Anthony, all four counts of providing false information to a law enforcement officer were one continuous criminal act with a single intent. As such, each false statement separately charged violates double jeopardy and must be reduced to one conviction based on one occurrence and course of conduct. In Hamill v. State, which we provided to the court, that's 934 Southern 2nd, 634, that's a Florida 2nd DCA case from 2006. The defendant was convicted of 15 counts of using a computer to seduce a child. At issue was whether counts 5 and 6, among other things, arose from a single criminal episode. In Hamill, the court articulated the test to determine whether offenses arise from a single criminal episode. In that test, the court articulated that...
Friar, let me stop you for a second.
Yes, Your Honor.
I don't seem to have benefit of what you said you provided the court.
I apologize, Your Honor. I gave that to the clerk, and I should have instructed that you needed to have that.
Okay. Okay, go ahead.
Okay, thank you, Your Honor. This test requires a court to look to whether there was a separation of time, place, or circumstances between the crimes, because those factors are objective criteria utilized to determine whether there are distinct and independent criminal acts or whether there is one continuous criminal act with a single criminal intent. The court went on to say that the spatial and temporal aspects of the crimes, looking at that criteria, a court can ascertain whether the defendant had time to pause, reflect, and form a new criminal intent between the occurrences. Your Honor, in finding that counts 5 and 6 in the Hamill case were a violation of double jeopardy, the court pointed to the fact that there was no temporal break in the conversation or a change in circumstances to warrant separate charges, where the conversation in question spanned several hours. Similarly, Your Honor, the false statements Miss Anthony made to Detective Yuri Melich occurred during the course of a single interview on July 16th, 2008. The interview was one continuous conversation, and similarly, there were no temporal breaks or other objective criteria that would suggest that the defendant had time to pause, reflect, and form a new criminal intent as required so as to not run afoul of double jeopardy. We've also provided the court with two other cases. That Hogue case, that is 511 Southern 2nd 401, and that was out of the 5th DCA. That's a 1987 case, and we also provided the court with Burke v. State. That's 475 Southern 2nd 252, and that's a 1985 case. It's our assertion that the Hamill case is similar in that it touches on the temporal aspects that are present in this case as well. However, the Hogue decision, the double jeopardy was invoked when the defendant was convicted of 5 incidences of leaving one scene because there were 5 people in particular who were left at the scene of an accident. Burke, on the other hand, is a case that's invoked a double jeopardy where there were 3 convictions of the defendant based on 1 transaction of 3 altered bills. And those convictions were charged separately. However, because they were found to be one act, double jeopardy was violated in those cases as well. Your Honor, in order to avoid a legal sentence, we respectfully request that the court sentence Ms. Anthony only for 1 occurrence, 1 count of providing false information to a law enforcement officer. Further, we reassert that there is an issue of materiality in these charges and should be read into the statute as legislative intent. Thank you very much.
Just a second.
Yes, sir.
Let's look at count 4
Yes, Your Honor.
of providing false information to a law enforcement officer.
Yes, sir.
Specifically, what is alleged in count 4?
Count 4 alleges specifically that on the 16th day of July 2008, that in violation of the statute 837.055, there was a knowing and willful violation in giving false information to Yuri Melich, a law enforcement officer. So that specific allegation was that Casey Marie Anthony suggested that she was employed at Universal Studios. However, it arose during the July 16th, 2008 interview, as did every other charge, Your Honor.
As a result of her telling the police that she was employed at Universal Studios, did the police have to take any resulting action with their investigation?
They certainly did, Your Honor. However, if we're to charge her, we have to charge her for the crime. And the crime here arose out of all 4 incidences were a part of the same continuous act, even though there were several false statements.
Count 5 alleges she violated that statute by doing what?
That